evening, voters. India has been ranked 81st amongst 180 nations in the Global Corruption Perception Index for 2017. As per Transparency International, that named our country as one of the worst offenders when it came to graft. Now, we really don't need any Transparency International index or any other survey to tell us just how deep the tentacles of corruption run in our country. You know it and I know it. It's one of the biggest talking points, and it has been like that for several decades now. Now, one would think that a government that came to power on the promise of fighting and ending corruption would at least bring in some tougher laws to fight and end corruption. Now, viewers, if you don't know, the amended Prevention of Corruption Act, the PCA Act, which we had from 1988, there was an amended version of that that's called Prevention of Corruption Act 2013, was cleared by the Parliament this week, by Lok Sabha this week, by Rajya Sabha last week, without any hue and cry, without any concrete debate, without any drama from the opposition. Just like that, it was cleared. Tonight we tell you what's in this bill. Is it really a closer step to cleaner India, or does it enable more corruption? For example, now to investigate any public servant, irrespective of their rank, to investigate a public servant, you will need government or relevant authorities' approval, not just to prosecute, but also to begin an investigation. Yes, my dear viewers, just a complaint by you will not do the trick anymore. Our MPs have decided to bring in an added layer for the babus, for the bureaucrats, for the public servants. That's not all. If a corrupt government has amassed if a corrupt government official has amassed huge amount of property, you have to prove the intention there, the connection there to their income. Not just the fact that he has disproportionate assets will do the trick. How is this a better law? That's the big question. As we welcome the Prevention of Corruption Act 2013 passed by our Parliament in this session, we ask, has the Parliament sanctioned more corruption?
All the chaos and drama and the clashes between the government and the opposition in the parliament, the Netas found time to unite. Briefly, to clear the amendments to the Prevention of Corruption Act. The government claims the amended act aims to enhance transparency and accountability of the government. But does it?
It has taken away the one provision in the definition of corruption which could have led to punishment to high-ups.
Some major amendments include clauses like requiring government approval for investigating public servants, immunity to government officers from arrest, bribing officials a criminal offence, bribe giver giving trial testimony will get no immunity, and so on.
Today, as a citizen, if I go and I file a case of corruption, no even investigation will take place in that case unless the government itself gives it permission.
The Prevention of Corruption Amendment Act of 2018 has been largely criticized by lawyers and activists alike, calling it the Protection of Corruption Amendment Act, clearly stating how that government permissions need to be taken to even carry out investigation of those officers who may be corrupt or who may be meddled in corruption.
So considering amendments like immunity from arrest to all government officers, the question arises, is the Parliament sanction of amendments to Prevention of Corruption Act a sanction to more corruption? The debate begins now.
We say good evening to Shailesh Gandhi, former CIC, Rajiv Pandey, leader of the BJP, Prashant Bhushan, senior advocate of the Supreme Court, Kailash Vastev, also senior advocate of the Supreme Court, Mohammad Khan, spokesperson of the Congress Party. Now, before I go to our experts, I just want to understand what our political representatives think about this bill that they have just voted for. So, Mr. Rajiv Pandey, Prevention of Corruption Act Amendment 2013. Is this a good bill? Is this a good law?
I personally feel that it's very good, because the time limit and time frame which is fixed for the trial of cases, otherwise the case used to get filed, and even the CBI cases in Bombay courts where I practice, I have seen 20 years no decision. So in this act, what I feel that the biggest part is that within 2 years you have to complete the trial. And if you want extension, then you have to reduce in writing the reasons for extension, and that extension cannot go beyond 4 years. That is my first thing. Second thing, I feel that giving bribe is criminalized. It's very good, because in bribing, there are two parties, taker and giver. If giver is not punished, then this will not stop. And third thing, which I feel the biggest part is that, the biggest good is that earlier a small time employee of a big corporates who used to involve themselves in bribing, so they used to get punished, they used to get charge seated. Now even the organization will be also charged for that corruption under the Prevention of Corruption Act. And fourth point, which I feel personally, that in the name of so-called writing and demonizing, and there was an extortionist culture by some so-called human rights activists, so that will also stop, because the government in every complaint will go and see and examine whether this any merit is there or not, and the people, the officers, the bureaucrats.
How will you examine?
The officers and bureaucrats will take
But there
decision.
is no investigation done. What are you going to examine?
Listen to me. When the complaint is placed before the person who has to give the
how will you
sanction,
decide the merit of a case on the basis of a complaint? How can you decide the merit of my complaint without an investigation into it?
No. You see, the moment it comes, even if before earlier this amendment, investigation used to take place, and if there is no sanction, you can't file charge sheet.
But now it's different, Mr. Pandey.
Right
now
it's
different.
The government will examine.
Yes.
No, I feel it is good, because the officers will think that if I am taking any decision, some extortionist or so-called whistleblower will not be after me, because we know very well how things were done. If I have to go after somebody, some honest officer, I will fight 10 complaints against him just to disturb him.
Okay.
So that investigation will stop.
Okay, we will come to the details in just a bit. I completely disagree with you, but I wanted you to present your 4 points that you have, which is why your party
no, you have right to disagree. I'm not here to convince you.
Mohammad Khan, we are very quickly getting in the views from our political representatives before we get our experts in. The bill has been cleared in both the houses.
Right.
What's your view? Is it a good bill?
Yeah. Well, I'm very glad to hear Rajiv Pandey read out those clauses and praise them. What Mr. Pandey should also do is give credit where credit is due. This bill is a modified, slightly modified version of the bill that was introduced by the UPA. And these were the amendments, the ones that he spoke of, about making bribe giving an offense, about the time limits, the more stringent punishments. Those were all envisaged by the UPA. What was not envisaged by the UPA, and which put us in a difficult position, as you saw from the debates, is that there's a lot of echo, Tanvi.
We're going to fix that.
The clause that was not put up for debate was the issue with regard to seeking prior sanction for investigation. That is something that we were against, Tanvi. And the truth is that we couldn't vote against the bill because the rest of the bill was our clauses. But because they snuck in this bill, this is something we wanted a debate on. We opposed it in the public domain also. But unfortunately, it has gone through, and we hope that this is something that the government will
I know you're getting a bit of an echo there, and we're going to try and fix that. But Mohammad Khan, so did you or your party representatives in the lower or the upper house raise this issue before it was cleared? Was there a debate on this issue?
Two of the unconnected debates of the Rajya Sabha.
This time?
Yes, in fact, Tanvi, if you
Before
look at the unconnected debates of the Rajya Sabha, which we
yeah.
downloaded also, page 62 onwards, it is given the objections raised by our members.
Okay then. I'm going to go across to our experts now. And Mr. Prashant Bhushan, let me start with you. Mr. Prashant Bhushan, what should an Aam Aadmi make of this corruption bill? We are being told it will protect the honest bureaucrats or government officials, and it will bring in more transparency.
Well, in my view, it should be called the Promotion of Corruption Bill or the Protection of the Corrupt Act. It is certainly not anything related to the Prevention of Corruption Act, because it makes several very retrograde changes. In the first place, it makes the permission of the government compulsory for even starting an investigation. Now, it is the corruption of the government which needs to be investigated, and if the government's permission has to be, it's like asking that, well, you have to take the permission of the thief before you investigate the thief. I mean, it's ridiculous. This was struck down twice by the Supreme Court, that this is totally unconstitutional to require permission even for investigating corruption. This was struck down in the Hawala case when it was engrafted as a single directive in the CBI manual. Thereafter, they engrafted it in the CVC Act and the CBI Act. Again, the Supreme Court struck it down. Now, they have brought it in the Prevention of Corruption Act. So, they want to control the matter at the investigation stage itself. The BJP representative was saying that the Act says that the trial should be completed in 2 years. What good is that when you won't even be able to investigate and therefore file a charge sheet? And secondly, today this Representation of People Act says that all election petitions should be decided within 6 months. Virtually no election petition is decided even in 5 years, despite the existence of that provision. It is all very good to say that, well, all cases should be decided within 6 months. You don't have enough judges, you don't provide enough judges, and then you say that cases should be decided within 2 years. It's all very good to say that, it's not going to be implemented.
Right.
Then you have removed the provision for criminal misconduct from the Act altogether. You see, criminal misconduct was a provision in 13(1)(d)(3) which said that if a public servant either abuses his authority to give an undue favor to any person, that's an act of criminal misconduct which is punishable.
Right.
Similarly, if a public servant grants an undue favor without any public interest, that's also criminal misconduct. Now, this was specially engrafted in the Prevention of Corruption Act, because very often you can't get evidence of a public servant actually taking a bribe. Very often the bribes are given in tax havens, etc., and it's very difficult to get evidence of that. Therefore, this was made as a separate offense, that if you abuse your authority or without any public interest give an undue favor to somebody, that itself will be misconduct or criminal misconduct which is punishable. Now, that has been removed, and now only in every case you will have to prove that the public servant has taken a bribe either directly himself or through somebody else.
That is
lastly,
if the case actually
they have
reaches
also diluted the provision.
Yes, that is if it actually reaches
Yes,
the point of prosecution or the trial, because right now we are expecting the public servant's boss or the relevant authority of the government to actually give the approval, please go and investigate this case of corruption or just on the basis of complaint. I find it ridiculous and that we are being told that this is to protect honest officials. Well, if they're honest, they're going to be off the hook any which ways. So what's the concern there? Mr. Kailash Vasudev, the other aspect, and I think Mr. Prashant Bhushan was going there, is this, that the new bill now requires to prove the intention to acquire assets which are disproportionate to the income. So not only now do I have to prove that Jayalalitha had assets which were disproportionate to whatever income she was getting at that point of time, I have to prove the intention. What does that mean?
In very simple language, it doesn't make sense. If a government servant has assets more than what they could have gained in the regular course of their employment, is an indication of corruption. Intentions were of no consequence under the Prevention of Corruption Act as framed after 1948. Today, we are imputing and giving directions to the act, which will itself create defenses and never lead to a prosecution. Prashant is right when he says that the purpose of removing misconduct is to remove suspicion. And suspicion very often is circumstantial, which leads to a situation where a government servant might not be proved directly involved in a transaction, but definitely by conduct has caused a situation of a loss. What is even more disturbing in this whole thing is the granting of a sanction even for investigation. In no law, at no point of time, either under the CRPC or under the more stringent laws of the drug controls, the NDPS, etc., has an investigation ever been subject to grant of permissions. Moment you do that, you are money laundering, Prevention of Corruption Act, NDPS, the Myriad Act, Drugs Act. There are so many acts where an investigation takes place on the receipt of a complaint. Whether you register as an FIR or as a diary, there is the entitlement to investigate. If you're going to stop investigation at this stage, you will play havoc into the system. Everybody will be very happy to work in cahoots with his boss and prevent an investigation into an allegation of corruption against him. Here, Prashant may correct me, if I remember my statistics right, as given in 2017 to the Lok Sabha, there were more than 6,500 cases of corruption pending in the country. It involved about 120 politicians and a couple of 18,000 odd government servants and private people. None of those cases have come to a decision as yet. CBI cases have been pending since 1900 for the past 22 years in many a case. Mr. Pandey said so. If that is the condition of the state of our system, where the police is not willing to investigate after the filing of a complaint, you think it's going to proceed further with permission from the government to investigate into a matter? You are putting the cart before the horse. You are putting honesty at a position where the corruption will overtake everything. It is time that this act was rethought of even before the president signs it and puts it into a notification. We will beseech everybody in this country, where we've been fighting for clean governance, clean systems, to relook at this whole situation rather than push it in a hurry. It's a 2013 draft. You've improved upon it.
You know,
from every sense, please don't take away essential provisions of the act.
Yes. You know, in every sense,
you have
I
brought in
see.
an act.
Go ahead, please finish your point. Yeah.
Then what I was saying is, if you're going to have this kind of legislation, then you might as well throw all the laws into the dustbin and so do what you want, we'll sit and do what we have to.
You know, it somehow gives me the picture that it's just making it difficult for a common man to fight corruption, especially when it comes to corruption within the government departments, which is the largest part. Now, so effectively what I'm being told is, if I go to get something cleared...
May I just...
I will have to, if I'm asked for a bribe from a position of power, and a person in a position of power is coercing me to give bribe, my only option is to quietly either not do anything about it and walk away and not get my job done, because if I pay the bribe, I myself am committing an offense, or I go and complain to the boss and get into the trouble any which ways, because the complaint may or may not get sanctioned for an investigation. So where are my rights as a citizen, and where is the protection to me as a citizen, Shailesh Gandhi? That's the point. Mr. Vasudev, I'll come back to you in just a bit.
I think the government has decided to make this a Protection of Corruption Act. They forgot the fact that P stands for prevention, not protection. This is precisely what they have done with the law. If somebody reports a bribe, after 7 days, he has committed a crime, because he can be prosecuted. To get investigation done. Therefore, when you apply for permission, it is obvious that the person will be informed that, look, somebody is asking for permission to investigate your crime, and then it dumps Article 14 completely, equality before law. If they feel that police is so bad and CBI is so bad and all the government machinery is so bad, then what happens to the common citizen against whom investigation starts? Compared to a government servant, he is completely helpless. So let's just forget all this. Let's forget the police. Let's do away without this. The point is, they have made it impossible. And they say in time bound, as Prashant rightly pointed out, nowhere does time bound work. Check bouncing cases and many other cases we've seen. Inquiry Commission Act says within 6 months an inquiry must be committed. It never works. This kind of time scheduling in India does not work. Even today, because there is sanction for prosecution, months are spent, at times years are spent before sanction is refused or given. Now we have it even for investigation. So therefore, you will keep pending the investigation, not give permission at all, and you will not take any decision. This is precisely what the law does,
right,
apart from the other things that my other panel members mentioned.
So let me
and
also
I'm surprised
say
that all parties have agreed to this.
Of course they will.
That is a very sad part of this.
These are convenient things. It just works out for everyone. I just wanted to put out some statistics because Mr. Kailash Vasudev did raise the issue. Now, if you talk about cases registered under Prevention of Corruption Act, in 2016, there were about 673 involving about 1,451 public servants, 6 politicians and 1,385 private persons. When we talk about pendency of cases, as of 30th June 2017, 6,400 pending cases under Prevention of Corruption Act involving 16,875 public servants, excluding politicians. So, Mr. Rajiv Pandey, now that you've heard our experts, please explain to us again, how is this a great step? What happens to the actual corrupt officials? Aren't you protecting them and promoting corruption?
Not at all, Tanvi. What is the issue? As far as the bribe giver is concerned, within 7 days, if he goes and explain that under duress I have made bribe, there will be no case against the bribe giver. Second point, what is the hue and cry people are trying to create? That after investigation, before charge sheet, sanction used to be given by the government to file charge sheet against the government officials. What used to happen? You know, in the case of many cases, investigation used to take place for many months. Investigation is going on.
But now it's time bound.
And then finally, before the filing charge sheet.
But now it's time bound. Now you've made it time bound. So why are you so concerned about those very small, minuscule percentage of honest officials that we have? Why are you so concerned about that?
Can I get?
What about the corrupt officials? Why are you protecting them?
Can I make my point? No, I am saying, so corrupt officials, the moment criminal case is file comes, the permission will be given for sanction.
How?
Sanction will be given.
On what grounds are you deciding?
Will take place.
On what grounds? On what grounds are you deciding? On what grounds are you deciding whether to approve a complaint or not?
Complaint. I am saying that complaint will be placed before the authority who will decide about the sanction. What I am trying to say,
how?
Earlier it used to get stonewalled after the investigation. Allow me to complete. Even at that time also, after suppose investigation has taken place and then till government has not given sanction, you cannot file charge sheet. Now the filtering will be done at the first stage. If there is an honest person and there is a vested interest of people have filed complaint, false complaint against the person,
who is deciding
they will take
this?
a call.
Tell me.
Otherwise,
who is going to decide this?
You see.
What is this relevant authority? Give me an example. For example, I want to complain about corruption in the local RTO office. No. Let's get specific here. For example, I have a complaint with a local RTO officer who is giving me trouble with the license documentation. I refuse to pay the bribe. I come and tell you, who is the manager of that official, this is my complaint. He is asking for a bribe. How will you decide whether my complaint is meritorious enough for an investigation? You've not done any investigation. How are you going to decide if there is any merit to my complaint?
What I am trying, you see, the complaint will be filed. That complaint will be judged on the basis of that.
On the basis
and then
of?
Authority will decide
on
about
the basis
sanction.
of what? I am supposed to now be an investigator and collect all the evidence, go do a spy cam while that man is asking me for a bribe, come and show it to you, prove it to you that there is corruption here, there is merit here. No, I want to understand. How will you decide on the merit of the cases? You have chosen to take all the power away
judge your
from the
complaint.
investigators. You have made yourself the judge at stage 1.
You know,
Explain
at that
to me
time
how.
also, even after investigation, even after investigation, sanction was not given. Nothing used to happen. So that time was wasted. And vested interest people used to file. There was a policy paralysis, and that's why to safeguard this honest officer, this clause is added. I am saying after filing the criminal complaint,
So,
the permission
rather
will
than-
be given or not given.
Okay,
And if
Mr.
there is a
Pandey, you are
discretion, can
telling
I
me
just make a
rather
comment?
than
Can I just conclude
blocking
my
it,
line?
rather than
No,
the
listen to me,
government blocking an investigation into a corrupt act at the prosecution level, now we're just going to do it at the initial stage itself. That's your argument to me. Okay,
No,
fair
why
enough.
you say
I'm going to
so?
let the viewers decide on that. I have to go first to Prashant Bhushan.
You are completely.
No, you just said
can I just
so.
make my point?
You just
that
said so.
The moment it comes, the moment I'm saying earlier used to happen, investigation man hours is wasted, and then at the time of filing charge sheet, no sanction is given. What is the use of that investigation?
Mr. Prashant Bhushan, I am also very concerned about the other aspect where now we have to prove the intention in a disproportionate assets case. What does that mean again? Because does it mean that I have to now prove that whatever was my undisclosed income or income via bribery is exactly the amount of money that was used to buy these assets, and hence my intention was wrong altogether? Is there any precedence that this kind of a system really works?
No, I don't think so. You see, the earlier law about disproportionate assets was perfectly correct, that if you are found with assets which are prima facie disproportionate to your known sources of income, then you have to show how you have acquired those assets, whether there are any legitimate sources of acquisition of those assets. If you can show that, you are off the hook. If you can't show that, you are convicted. Now they say with this amendment that the prosecution not only has to prove that you are in possession of disproportionate assets which you cannot explain, but further the prosecution will need to prove that you acquired these assets with some guilty intent. Now, how does the prosecution prove that you acquired this? It's just like the change that they have made in that criminal misconduct, where they say that you have to prove that you have taken a bribe either for yourself or through somebody else, that you can't charge or prosecute a person for abusing his power as a public servant to give undue benefit, or to give undue benefit without any public interest. That's no longer a misconduct. You have to prove that he has taken a bribe either directly or indirectly. These are the nature of the changes that have been made. Essentially, they have made it virtually impossible to prosecute the corrupt. At the first stage, you require permission of the very person or the boss of the very person that you need to investigate, who is often involved with that person. At the second stage, you require to prove that he has taken a bribe, which is usually very difficult to prove, or that he has acquired disproportionate assets with guilty intent, which is also very difficult to prove. So, therefore, they have made it virtually impossible to prosecute, and that is why the Officers Association congratulated the government that the government has done a great thing in protecting all public servants from prosecution for corruption.
Yes, they're all celebrating tonight. All the government officials and the bankers, they're all celebrating the immunity that has been given to them, handed over to them on a platter. Mohammad Khan, I find it very, very hard to believe that how did you guys just let this pass? You may have started the process of bringing about a new law, but is this the law? Is this the law that you wanted? How did you let it go? Unless you were also thinking of benefits to your own party leaders.
Not at all, Tanvi. In fact, as your
political
panelists have pointed out, many of the
scheme to
benefits
get rid
accrue
of.
largely to serving officers. We are not in government, so therefore we don't have a dog in
You
the fight.
will be in
But let me
government
tell you about the
at some
timeline and the
point, or
history
have
of
you
this
lost
law.
all
When the
hope?
first draft was circulated, no, of course. Well, no, of course, I believe we will be in office next year itself, by which time we will rectify the havoc that these people have played on governance. But it is imperative that you understand the timeline, Tanvi.
Why did you
when
pass
the
it
original
now?
draft of the bill came about, which was sent to the standing committee,
Yes.
which was, I'm telling you, sir, I'll tell you, because again, you'll understand it's a catch-22. Look, when we came up with the standing committee report and this bill was put before Parliament, we were voted out of power. Now, when does this amendment, the one that you and Mr. Prashant Bhushan rightly have the greatest objection to about sanction for investigation come in? It comes in after the BJP government is sworn in. We oppose it at that time itself. We ask for it to be sent to the standing committee again. We are told no. Sir, Kailash sir, you will attest to the fact that every time we have challenged a bill, and we can't vote on a bill selectively. We can't say we approve clause 1 but not clause 2. Which is why at the very outset I referred Tanvi's attention to page
Did you
62
not
of the
have
Parliament
why
debates.
not? Did you not have
That's not a
problems
parliamentary
with
debate take
specific
place now. But
clauses
anyway,
of
Tanvi,
the
There were
instant
clause by clause
talaq
voting.
law?
We had a choice
Did you
before
not
us.
have problems with the triple
Tanvi,
talaq
we had
specific
we had a
clauses?
we had a
Did you
choice
not send
before
it
us.
back to a standing
I'm
committee?
answering you.
Why not here?
Exactly. I was going to give you the example of the triple talaq bill as well. I was going to give you that example. Whenever we raised 3 doubts in writing about the strength of the bill, and the amendments we proposed were only to strengthen the bill, we were painted as a party that is trying to stand in the way. We had to take a call here. We had to voice our objections to this bill, and ultimately we had to
come on,
decide whether we
Mohammed Khan.
support. because the
I
BJP
don't
kept
buy
saying
this.
Half of this bill is
I
yours.
don't buy this.
Half of this
You
bill is
have
yours.
happily
More than
become
half of this bill
part
is the
of that
handiwork of the-
parliament
is the handiwork
that
of the
has
UPA
given
too.
sanction to
Tanvi, you may
corruption.
buy it or not
And
buy
you're
it,
telling
but
us
the
it's a
truth is,
catch-22
we
situation.
in the opposition can only oppose to a certain. Tanvi, we opposed it on the floor of Parliament. Please
Walk
read
out
Mr.
of the
Anand Sharma's
parliament.
speech.
You guys are so
Please
good at
read,
it. Walk
the
out of the
unconnected debates
house.
Parliament.
You're so good at
Of
it.
course.
Do
In
drama.
Parliament
Do
we raised the
chaos.
issue.
At
In
least
the
make
House
some
we raised
noise
it, Tanvi.
so
Where
that
else will
people
we
of
raise
this
it?
country know
Tanvi,
that you
we
care
raised
about
the
this issue.
We have raised it and then we had to vote on the bill.
Kailash was this.
I'm
Do you
sorry,
buy
it's
this?
disingenuous
Do you
to
buy
suggest that
this?
no,
That
you
they didn't have
you
any option?
You raised it in Parliament, but you should have voted against the bill. We don't disagree with 4 of the clauses because 4 of the clauses were drafted by us. It is this particular clause that they have snuck in that we have an objection to, and we've raised that objection in Parliament. We are not, ultimately it is up to the government to decide, and they have gone against that, and we will hold them to account both within and outside Parliament.
Okay,
It is a fact.
okay.
It would
Let
be
me
very easy for me
ask
to tell you
the
that,
other
no, Tanvi, we
panelists.
support the bill in its entirety, but we are not doing that. We are making a distinction.
I want to just come in here for a minute.
Yes, please.
I just want to come in here for a minute. Why couldn't this act be made more radical? Why have you to dilute all the provisions which accounts for corruption? Why must you bring about an act? Please see the earlier act and the 1948 act. The whole purpose of stopping corruption stands defeated. You are going to permit everyone to do what they want. And here I have a question to government. In the past few years, you've had some of the most massive bank scams. Massive. We've heard about Mr. Modi going away. You've heard of Mr. Choksi running into the Antiguan countries with a passport from that part of the world. You've heard of Mr. Malia running away from here. You've heard of Mr. Lalit Modi running away from here. You've had all sorts of people who have made money and got away. Whom are you hanging? Have you brought back any of those persons who are responsible for these massive scams? Have you brought back anybody who's responsible for causing so much damage to our economy and our reputation? You're giving a worldwide image now that we were number 100 on the corruption list. Today we'll go to 150. This is what you are doing. No one is going to buy this story. Please save us Indians from more disgrace. Give us a situation
We are trying
so we
to
people
attach
of
the
India can
assets
live
of
correctly.
The people who have left this country. No, you see, this government has taken action
Sir, you have
against
not
them.
succeeded.
We are trying, even
You
we are
have not
fighting case in
succeeded
the London.
anywhere.
No, you have not succeeded because there are certain laws. It is going
I
on.
take
We are
exception.
trying our best.
Please,
How
please,
you
just
can
1 second.
say-
Just 1 second, sir. Just 1 second, sir. In other countries where there are fugitives from justice, they come back very fast. It is our system which has been fighting for years together to bring them back. You couldn't bring back a Kotruchi in 1960 from 1984 onwards. He died outside. You couldn't bring back the Purulia cases. How many people have you brought back for offences in this country? Please tell me. I'm not speaking of which parties in government. I'm speaking of government per se. You support corruption because that is the source of your income. That is what I feel. And I'm saying it on television. Politicians support corruption. That is the game today. And it hurts. It hurts like hell.
Yes, Mr. Rajiv
Ask a
Pandey.
citizen
May I add
on the
one
street
thing?
when he goes to a
I
government
was
office.
reading the debates again, Tanvi. Mr. Hussain Dalwai of the Congress, Mr. Hussain Dalwai of the Congress repeatedly asked for this bill to be sent again and again to the select committee so this clause could be reviewed. That is another important thing. You say we should have walked out, Tanvi. Had we walked out, we wouldn't have been able to debate. We have raised our position clearly and compellingly against this. And that is what the opposition's job is. We would be remiss in our responsibility if we just took the easy option and walked out. Did we walk out in triple talaq?
No, obviously no. I don't want you to walk out of a debate. The point was to say make noise about it and stop it and block it if you don't agree with the law.
We did, which is what I'm telling you. Which is what I'm telling you. We asked again and again. Mr. Dalwai, Mr. Hussain Dalwai repeatedly said, send it to the select committee. This clause needs examination. You know that the speakers are allotted a limited
What do you
amount of
think?
time
What, okay,
by
you're talking
the
about the
Speaker of the House
sanction.
or the Vice
You're talking
President in
about the
case of Rajya
sanction
Sabha.
clause. You're talking about the approval for the investigation clause.
Yes,
what
the
about the
sanction clause.
disproportionate assets and the
Yes.
owners to now prove the intent? Are you okay with that one?
That was framed by the Congress.
Well, I think intent was always there.
Why?
Actually,
What do you
that's-
mean by
those clauses
proving
are
the
in the
intent?
old
I think intent was always there under Section 15. So, Kailash sir, my reading of the law and your reading would undoubtedly be much more informed. I thought Section 15 of the PC essentially did provide for men's
no, we
ria
are
to
not
be
informed,
considered.
sir.
I personally may be wrong, but I think that was the reasoning why it removed.
Correct.
So, perhaps that is one of the reasons why that clause was not the thing. But
see-
we took great objection to
No.
this
No, no,
particular
no.
requirement that now you must investigate dilution of Section 197 CRPC, that there should be a dilution of this standard. That is what we objected to, that there should not be a sanction required for investigation. By God, we are the ones who brought in that requirement, that there should be a sanction for prosecution but not for investigation. Why would we dilute our own law? And Tanvi, while we are on the subject, there is a larger question here. The BJP government has squandered the greatest opportunity for criminal justice reform. They could have brought in the Lokpal, something that Prashant sir will tell you.
Yes,
They have
actually,
not
I do
even
want to
responded
go.
the Supreme Court's
I
strongly
do
worded
want to go
condemnations
across to
on that
Mr.
part.
Bhushan on
the
that.
Whistleblower Act, which we
Bef-
passed.
before I let him
we
go-
passed the Lokpal, we passed the Whistleblower Act.
Right.
They just had to operationalize it. They didn't do
Right,
that. This
Mr.
is window
Bhushan,
dressing,
would it
Tanvi,
have
you know
not been
that.
a little bit more sensible, to have that decision-making power with the Lokayukta? If the concern is to protect the honest officials, let the Lokpal actually decide on whether a complaint is meritorious enough or not. Do you think that would have been a more sensible way of going about it?
Well, that's already there in the Lokpal Act. The Lokpal Act says that it's the Lokpal which will decide whether a complaint needs to be subjected to a preliminary inquiry or a regular investigation, etc. And even the prosecution sanction is to be given by the Lokpal, not by the government.
But that everybody
unfortunately,
seems
the
to have
government
forgotten
is not
about.
appointing the Lokpal.
Yes.
Yes, but the government is not appointing the Lokpal, and therefore by not appointing the Lokpal, they are reserving all this power to themselves. And they are saying that, well, we will decide whether a case needs to be investigated or not. And all these various other dilutions. Just one more thing I wanted to point out, that you see, Kaushik Basu, who was the earlier chief economic advisor, made a statement that the bribe giver should not be subjected to prosecution. Today under the law, he is subjected to prosecution for abetment. Now, there was a half truth in what he said. See, bribe giver gives a bribe in two situations. Some poor people are forced to give a bribe for even getting their legitimate entitlement. For example, you have a right to get a ration card, but the ration card dealer says that I will give you a ration card only if you give me a bribe. The poor person has no option but to give him a bribe in order to get that ration card. So, if you are giving a bribe to get your legal entitlement, then you should not be prosecuted for corruption under the Act. But if you are giving a bribe for getting more than your legal entitlement,
Right.
then certainly you should be prosecuted. That distinction should have been made. Unfortunately, even that has not been made.
Correct.
Here they have just said that a bribe giver will also be prosecuted. Even earlier he was to be prosecuted as an abettor.
Right. So, Mr. Pandey, do you want to tell us why you didn't think that was necessary? You don't think there should be a distinction if for my legal entitlement I am being forced to pay some money or other kind of reward?
You see, just Prashant Bhushan ji has said that if Lokpal would have been in place, then Lokpal would have given the permission for even the investigation in the case. Right now, as there is no Lokpal, and government has taken a call that to protect the honest
Why
officers,
is there no Lokpal?
let the complaint be filed.
Government becomes the
Government
Lokpal,
government will examine the merit of the complaint, and then investigation can be done. I don't think that why this so much hue and cry. You don't have faith in the government. That's the problem. It is elected every time after 5 years.
You can't blame the voters for that. You are telling me you don't have faith in the government. I am complaining to you about the government and the corruption done by a government official. So obviously at this point of time, I am not going to have any more faith in what that corrupt official's boss is going to decide on. Why don't you just get a neutral party?
Understand this, the whole. No neutral party. I'm saying why, if there is a discrimination in giving sanction, people will go to the court. In many cases where sanction was not given, people have gone to the court and court has directed.
See, now that's the unfortunate part, Mr. Pandey. For everything, the citizens raise a problem with the government. You tell us to go to court. If for everything we have to go to the court, what good is the government?
Demonstrated that there was
No,
proof.
and one more thing which in this debate is missing.
No, there's a fundamental flaw in that reasoning. If there is no investigation, what will you go to court against?
Not in the criminal misconduct. Criminal misconduct, it is not added. It is added in the definition of the corrupt public official about the test of intention, not about the definition of the criminal misconduct.
The test of intention,
If there is a criminal misconduct,
the
you have to
test of
just prove that he is
intention
having
to
possession
prove
of
that I got
disproportionate
these
assets.
disproportionate assets from dirty money. How do you prove anybody's intention? How could I have
That
good
is the-
intentions
that-
if I'm amassing
No,
disproportionate
Tanvi,
assets? Yes,
no,
Mr.
I have a
Bastev.
question here.
Yes.
No, I have a question here. Just now we are told by Mr. Pandey that if you don't give the sanction, you can go to court.
Yeah.
You have a bar of 2 years, extendable by 2 years
I
for the
said-
purposes of a trial.
No.
The
I
court
said
gives you the
something
sanction
else.
after a
If
year and a
there is
half.
a sanction is not given on the basis of, no, listen to me, sir. What I said that if there is a
I'm listening,
discrimination,
sir.
if there is a abuse of power by the authority, and you find that I had a very good complaint and government has shielded a corrupt officials, you can certainly approach the court. That was my point of view, sir.
More litigation, because
That I
that's
can.
what the government
That I will.
expects us to do, go running to the court, because they will
So
not
the
do their
purpose
job
is-
saying the same
efficiently.
thing.
I'm going to
But
go
the
across to
problem
some of
is,
our viewers
you know,
right now.
the
Intention here is to make our viewers aware of what kind of a law has been passed, which is why we have experts sitting on this panel, which is why we have the BJP and the Congress. Now let's hear it from our viewers. Sandeep is on the phone line calling us from Bengaluru. Good evening, Sandeep.
Good evening. I'm Sandeep Bulganavar from Bangalore, Indiranagar. And I would like to say only one thing. Why do you want to penalize the person who's giving the bribe? Because it's very simple. The person, the official who is not approving or sanctioning whatever it is, within a period of 1 week, is assumed that he is asking for bribe. Or else, let him give an explanation in writing for the reason for his refusal. Very simple.
All right, Sandeep. Thanks so much for calling in and sharing your views. I'm going to go to Shailesh Gandhi. Shailesh Gandhi, what options do we have now that the Lok Sabha and the Rajya Sabha have cleared this? Like Mr. Bhushan was pointing out, there have been Supreme Court judgments in the past. Is our option, like the government is telling us, to go to the court? Or what can we do? Or hope that the president doesn't ratify this?
I think this law itself should be challenged. This
go to
amendment
court
to the
only
law
after
must be
ratification.
challenged. And let me give you one simple thing. They have systematized the whole corruption setup, saying that after a bribe is taken, after 10 days, do whatever you are supposed to do. If a refund has to be given, give it after 10 days. If a ration card has to be given, say you give me the money today, and after 10 days only will you get your ration card. So therefore, they have created a huge armor through which nobody can be caught, and nobody will complain of bribes. That is what they will attain. And what they will do is later on say, the number of complaints for bribes has gone down. Brilliant, brilliant way of playing around with statistics. What is to prevent, not prevent, most probably this will happen. Every favor against a bribe will be done 8 or 10 days after the bribe is taken. Please tell me, either one of these people from the political parties, how will this not happen? Why will it not happen? And you will say, I'll arrest the bribe keeper, the bribe giver will never come before anyone. And therefore, yes, perceptibly in terms of numbers, the number of corruption against complaints and number of corruption against bribes will go down. And therefore, it will be touted as a great achievement of this Protection of Corruption Act.
That is so depressing to even think about that scenario, but I do agree with you that that is a possibility. Now, just to add to that, no, Mohammed Khan, my apologies. We'll have another debate.
It's been designed.
But I'm completely out of time on this one, so I do have to wrap up. I just wanted to finish that point by saying that one also has to keep in mind that because now giving bribe is an offense and they have taken away the immunity from the bribe giver against prosecution. So if you go ahead and give statements in the court during the trial, those statements can also be used against you. The whistleblower in many cases will not have any kind of immunity as well. Just wanted to bring that out. Thank you to all our panelists for joining us this evening. Big disappointment. Look at the way the political parties came together to vote on this one, viewers. Because when it comes to corruption within their own government departments, everybody is all right with it. Everybody wants to add one more layer of protection for their own politicians, for their own babus. Everybody is all right to make life difficult for you. Now, every time a political leader comes to you, be it a minister or a local MLA, and tells you that I'm going to fight against corruption and I'm going to weed out corruption from this country, throw this bill in their face and ask them the question, how is this helping you fight corruption?